In 2020, the Divorce, Dissolution, and Separation Act restructured how adult relationships are legally terminated in England and Wales. The historical requirement to prove specific behavioral facts, such as adultery or unreasonable behavior, has been removed entirely. Today, the process relies solely on a single statement of irretrievable breakdown. This diagram outlines the procedural architecture of a modern divorce for dissolution under the Family Procedural Rules 2010. We will map this strict statutory timeline from day zero to the final order. Advising a client today requires mastering this administrative timeline and its critical milestones, rather than litigating past conduct. We begin with this calendar block, representing the statutory threshold under Section 3 of the Matrimonial Causes Act 1973 and Section 41 of the Civil Partnership Act 2004. An application cannot be issued within the first year of the union. The restriction lifts on day 366. Once that one-year mark is passed, applications can be submitted either as a sole applicant or jointly. Here is the layout of the My HMCTS digital portal. Initiating the process requires filing the D8 application for a matrimonial order, providing the marriage certificate, and paying the court fee through this interface. Submitting this application starts the clock on an inflexible administrative process dictated by the Family Procedure Rules. Looking back at our timeline, we established day zero as the application issue date. Upon service, the respondent has exactly 14 days to file the D8B Acknowledgement of Service. At this stage, the grounds for disputing the application are strictly limited. A respondent can only challenge the court's jurisdiction, the legal validity of the marriage, or prove that the marriage has already legally ended. The first major statutory waiting period follows. The applicant must wait a minimum of 20 weeks from the issue date before applying for a conditional order. Pronouncement of the conditional order signifies that the court is satisfied all legal and procedural requirements have been met. Crucially, the conditional order is an intermediate decree. The legal relationship remains intact, and the parties are still legally married or in a civil partnership. Following the conditional order, there is a final mandatory waiting period. As shown here, a minimum of 6 weeks and 1 day must pass before an application can be made for the final order. The final order is the definitive legal decree that dissolves the union, officially permitting the parties to remarry. In a sole application, the respondent has a statutory mechanism for protection under Section 10 of the Matrimonial Causes Act 1973. They can apply to the court to delay the final order. The court will maintain this delay until it is satisfied that the applicant's financial provision for the respondent is fair and reasonable. While the timeline operates mechanically, the final order is never guaranteed if financial equity remains unresolved. Resolving financial negotiations is a concurrent priority during these waiting periods. Practitioners must also evaluate strategic alternatives. On this decision tree, if a client has religious objections to divorce or the relationship breaks down within the first year, judicial separation is the correct statutory pathway. Unlike divorce or dissolution, there is no one-year statutory bar to applying for a judicial separation. The order ends the legal duty to cohabit, but it does not dissolve the marriage. Consequently, neither party is legally permitted to remarry. Because the marriage remains intact, certain financial remedies, specifically pension-sharing orders, are legally unavailable. Judicial separation serves as a precise statutory tool designed to protect clients who require legal separation without complete dissolution. We can now see the complete procedural architecture. The 2020 Act has replaced an adversarial system with a predictable, timeline-driven administrative process. Effective legal counsel relies on strict adherence to the Family Procedure Rules timeline, an understanding of the conditional order, and the deployment of strategic alternatives like judicial separation when appropriate. By mastering these procedural mechanics and statutory thresholds, practitioners ensure their clients navigate the dissolution of their relationships with clarity, absolute compliance, and strategic foresight.